let's get started. We don't have any bill hearings today. Hooray. We do have several bills still to get through, though. So we're going to take these up in numerical order. Or, yeah, I guess it's numerical. Let's start with HB 2697. Natalie.
Thank you, Mr. Chairman. House Bill 2697 would make changes to the process for evaluating and treating people who are undergoing evaluation for competency to stand trial. And then it would allow that evaluation and treatment to occur at various facilities.
We have any questions for Natalie? If not, I have an amendment, which Natalie will send to Kathy, and Kathy will send to us. While it's being distributed, I'm going to have Natalie explain the amendment, but as you'll recall, this is a bill I've been saying we're going to be working for quite some time. KDADS has been working with the various partners to come up with this amendment. You, I think, got an email this afternoon from Disability Rights Center. They were an opponent, and they sent us an email indicating they are no longer an opponent now that they've seen this amendment. So I think everyone's on board, best that I've been told. So we'll get the amendment, and Natalie will walk us through it. Okay, it's hit my inbox. So Natalie, would you like to begin?
Sure. Thank you, Mr. Chairman. The first kind of the bulk of this amendment is we're adding in KSA 223301, which is the definition section for this group of statutes. And we are defining, if you scroll all the way to the bottom, an appropriate state, county, or private institution or facility. So that new definition would be a place that has sufficient resources, staffing, and space to conduct that evaluation or restoration treatment of the defendant. That term would not include a jail or a correctional facility unless the administrative head or the law enforcement official in charge of that jail agrees that the facility has the appropriate physical and care capabilities. And so to facilitate those services being provided by the state security hospital or its agent, or the state hospital or its agent, a qualified mental health professional who's qualified by training and expertise to conduct competency and restoration treatment, an individual who is qualified by training, who is licensed by the Behavioral Sciences Regulatory Board, or a physician who's qualified, who's licensed by the State Board of Healing Arts. So then throughout the bill, where it talked about the various facilities, sometimes it would talk about the appropriate state, county, or private institution or facility. Sometimes it would talk about a psychiatric or psychological clinic. Sometimes it would talk about a mental health clinic. All those terms have been changed to match that new definition that we're using. So that will be consistent throughout the statute, and any of those facilities listed there would be able to provide those restoration services or evaluation services. The other kind of big change made throughout is changing county or district attorney to prosecuting attorney. That was an issue that was raised by the Attorney General's office, among others. There are some instances in new language where county or district attorney was used, but there were some instances in current law that weren't proposed to be changed that said county or district attorney. So all those references should now be prosecuting attorney. On page 3 there, you'll see another provision about the jails, just reinforcing the idea that the head of the jail would have to agree before those evaluation and treatment services would be able to be offered in the jail. Some more just consistency in the language on page 7. We kind of use different terminology to talk about the head, the chief medical officer, or the head of any facility. So we made some changes to make that consistent there. And then on page 10, you have some changes here in paragraph 4. So if a defendant who's charged with a felony is receiving treatment and they're not deemed a present danger to their self or to others, and they object to taking medication prescribed, then that defendant's objection would be recorded in the defendant's medical record. That that second part was already in there. And then written notice would have to be given to the court where the criminal charges are pending. And then that medication would only be able to be administered over the defendant's objection if the court finds that the medication is substantially unlikely to have side effects that may undermine the fairness of the trial. The medication is medically appropriate. It's the least intrusive less intrusive alternatives have been considered. The medication is necessary to advance significantly important governmental trial interests, and the administrative head or the law enforcement official in charge of the jail has agreed to having that medication administered over the defendant's objection while they are in jail. So those are the changes to the medication provisions that you heard about. And then the rest are just those similar, changing county and district attorney to prosecuting attorney, and then aligning the facility definitions with that new definition of appropriate state, county, or private institution or facility. And I think that covers it, but I can take any specific questions.
Questions for Natalie? Are you willing to carry this on the floor, Representative Wheeler?
He's volunteering to carry it on. Thank you. And I'm sorry, I just missed it and I can't find it in here. This part where the defendant objects to taking medication in the court, what?
Sure. So those pages are on page 10. So if that defendant, now the way that it will work, if they're charged with a felony, they're receiving treatment under this section, and they're not deemed a present danger to themselves or others, they are taking medication that would be prescribed for the purpose of restoring that defendant's competency. If the defendant makes an objection, then it's recorded in their medical record, and then written notice of that is sent under the way the bill is currently drafted. The notice is sent to the medical director. This would also require notice to go to the court where the criminal charges are pending. And then the only way that the medication could be administered over the defendant's objection would be if the court makes those findings there listed in the balloon on page 10. Whereas, before they were able to just administer it over the objection in certain circumstances.
Okay, thank you.
Other questions for Natalie? I'm going to move the amendment. Is there a second? Representative Hoheisel? Discussion? A lot here. We can take our time if you're still reading. Representative Humphreys.
Thank you, Mr. Chairman. So can you I'm sorry, I think I was a few minutes late. Who brought these amendments and who worked together to get them all?
Yeah, so over the last several weeks, KDADS has been working with a number of parties, including, I think I said before you walked in, Disability Rights Center was the only opponent. They emailed us this afternoon that they are no longer opponent. They're good with this amendment. So to my knowledge, everybody who had concerns has been briefed on this and seemed to be okay with it. No worries. Okay, if there's no further discussion, I will close and move my amendment. All in favor say aye.
Aye.
All opposed say no. Motion carries. Now on to the bill. Any further amendments? I hope not. Okay. Okay. We have a motion concerning House Bill 2697. Representative Hoheisel.
Thank you, Mr. Chair. I move we pass HB 2697 favorably as amended.
Second by Representative Neely as a substitute. No. Oh, no. How would you like it? Yeah, because it's not got it. Okay. Discussion. Representative Samsel.
Thank you. A quick question, I hope, as I dive through this, but it's on page 10, and I was looking at those subparts A through E on when the medication may be administered over the defendant's objection. Is what happens under subsection E if the administrative head or law enforcement official in charge of the jail doesn't agree to have the medication administered over the objection?
Mr. Chairman, so in the event that, the way that paragraph is set up is that the court has to make those specific findings that all 5 of those things are the case. If the court doesn't make a finding that that's the case, then I don't think the statute would allow the medication to be given over the defendant's objection at that point.
Thank you. Thank you, Mr. Chairman.
Any further discussion? Not. Representative Hoheisel? You can
Close.
For the motion, all in favor say aye.
Aye.
All opposed say no. Motion carries. Affirmative votes wanting to be recorded: Neely, Hoheisel, Ohabison, Carmichael, and Heiberger. Let's look at 2736.
Mr. Chairman, House Bill 2736 limits the liability of optometrists and ophthalmologists who report information to the Division of Vehicles relating to a person's vision.
Any questions for Natalie? Are there any amendments? Representative Carmichael.
Thank you, Mr. Chair. I'd ask that my amendment be distributed electronically. While that's being done, it's a simple amendment. It reinserts the words "in good faith" on page 1. And at one time, I even remember the line number. It's about 31, if I recollect. And if I might explain.
Yes, go ahead.
Thank you. Mr. Gallimore of our staff burned the midnight oil last night. Some other lawyers not in this room burned the midnight oil last night. Same can be said of lawyers for the Kansas Optometric Association. We've met and discussed the circumstance, and I certainly now have an appreciation of the facts and circumstances of the lawsuit that brought this matter to the association's attention and caused them to bring the bill. I think they also can appreciate my concern that if we struck the words "good faith," it would mean that there would arguably be immunity for eye doctors who rendered reports to the Division of Vehicles in bad faith. In other words, people who are running a eye certification mill. And I don't mean to say that those things do exist, but I think we all came to the agreement that really we could accomplish their purpose with the rest of their language, but that we were all in agreement that we wanted to make sure that we only protected doctors who are acting in good faith, not somebody who was making up the reports. My apologies to Ms. Brown. I neglected to visit with her about this. I hope that she's been appropriately informed. I see her nodding her head affirmatively. So I think everyone involved was in agreement. There is a second provision in this amendment, and it makes this law effective upon publication in the state register.
Like to move your amendment?
I would like to move my amendment.
Second by Representative Hoheisel. Any discussion on the amendment? Representative Humphreys.
I'm sure you explained it great, but so it seemed like when I asked in the hearing yesterday what the issue was, it seemed like the answer I got was that those words "in good faith" were kind of what the problem was. So could you just elaborate a little bit more on adding it and what that does and what you think of the rest of how it goes on?
Okay. Yeah, I'll do my best to explain that. I want you to know that I'm not the expert on what's going on in a case that is in Saline County. The attorney for the Optometrists Association was the expert. And so he kind of explained that to me, but unfortunately he can't testify. Only I can say what I can say. At first, I think the thought was that I believe at first the thought was that we needed to take out any standard related to the report in order to provide the doctors the protection that they thought they need. In other words, good faith, bad faith, accident, negligence, etc. You may remember we even talked in the hearing about protecting medical negligence, that wasn't what they were looking for. And after we had further discussions, I think we all concluded that it was probably best to leave a requirement of good faith in the statute because, out of fairness, we're not here, and I don't think the associations are here to protect doctors who act in bad faith, phony up reports so a CDL could be issued. And I think as they reflected on what they really needed, I think they realized that we could leave the phrase "good faith" in there. And by implication, claims for bad faith could still be brought, but they're doctors who are practicing within the standard of care and being careful doctors. They can show the issue, the report in good faith and qualify for the immunity. So, I mean, that's my best explanation of where people were at.
Any further discussion? Representative Heiberger, then we.
Yeah, I don't want to torpedo a well worked out amendment, but it seems like really the only thing that this bill does after reinstating in good faith is cleaning up some statutory language and then striking that phrase to safely operate a motor vehicle in line 33. Is that accurate?
And adding the last sentence of their amendment, which I think is actually a statement of the existing law, but I hate to speak for them, but I think they feel more reassured if we put that in the statute.
Representative Wheeler. Representative Samsel.
Thank you. I had a similar discussion before we got here about that because I thought maybe the good faith piece was one of the key issues too. And it may be in their lawsuit, but the change that was important here is later it looks like in the statute, and it takes out it's just strictly related to vision now. So the factual stuff that they kept talking about is all this pares it down to. If it in line 32, when it talks about other ability of an applicant for a driver's license, it gets rid of those other things and narrows it in that context, was my understanding. That's not the best explanation, but because they narrowed that later language in there, the good faith piece was okay to put back in, if that helps, is my understanding.
Representative Wheeler.
As I am understanding it, and I join counsel that I'm not an expert either, but in visiting with the people who have visited with me, I think this came about, the good faith issue, is because the lawsuit in Saline County is not based on the negligence of the doctor, but has alleged that the doctor acted in bad faith, contrary to what the statute required as good faith, so that if we have that statute of any kind of faith, then they're going to allege bad faith. And I think that kind of got close to it. No, I'm getting a blank stare. So perhaps that's the way I kind of read into it. There's no allegation of negligence. It's just bad faith. So let's just take out the standard of faith, which I think was the wrong move.
Okay. Yes. More hearsay? Because we have lots of hearsay today.
I don't
Representative Carmichael.
I don't think any of us want to take out a standard of faith. Okay. No matter what it has to do, people have a right to faith, but we are preserving immunity for those who act in good faith. And if it can be proven when it's a high burden that someone was not acting in good faith, then I don't think any profession, I know I can speak for my own, we don't want practitioners out there acting in bad faith. And I don't think that optometrists and ophthalmologists would want that either.
Representative Humphreys.
Thank you, Mr. Chairman. So I think this has to do with the amendment, but it kind of has to do with the bill. But I want to ask the maker of the amendment. And so, if I may, Mr. Chairman. Okay. So, reading just kind of the gist of the sentence, no optometrist or ophthalmologist shall be liable for damages to any person, blah, blah, blah. That's kind of where we are now. Because you're keeping in the good faith. So what it said before was no optometrist or ophthalmologist shall be subject to a civil action for damages, blah, blah, blah. So because you're keeping in the good faith, it seems like one of the differences is before they can't be subject to a civil action. And when we change it, they can't be liable for damages. And those are two different things. I mean, is that one of the differences here, since you're keeping in the good faith?
With the chair's permission, the only language that we're changing from the amendment that was recommended by the associations is the good faith, which was stricken. All of the rest of this is the very same thing as what the associations asked for, except we're putting back in good faith and making it published, effective upon publication. So they're getting all of the rest of the language they wanted. But, you know, in the nature of compromise, sometimes we do have to chat with each other. And I think we came to the final conclusion that none of us wanted to protect doctors who are acting in bad faith. And if we take out good faith, the rules of statutory construction say that the legislature attempted to accomplish something by what it does. And if you take out a requirement of good faith for immunity, then the presumption is that we were intended to protect any kind of conduct, and that's not in anybody's interest.
And I appreciate the amendment, and I'll vote for the amendment.
I appreciate that.
My question was a little bit different, but maybe I'll get to that when we talk about. I thought it had to do with the amendment, but maybe it has to do with the bill. Thank you, Mr. Chairman.
Any further discussion on the amendment? Okay, Representative Carmichael, you can close.
I close and move the amendment.
You've heard the motion. All in favor say aye. All opposed say no. Motion carries. Are there further amendments? Okay, not seeing any. A motion concerning 2736 as amended. Representative Hoheisel,
Thank you, Mr. Chair. I move we pass out HB 2736 as amended.
is there a second? Representative Kincannon, discussion? Representative Humphries.
Thank you. So yesterday when I asked, well, what is the real gist of this? Like, what is this about? The answer was that good faith piece. I mean, that's what I heard as my answer. And so, okay, so now we put it back in. So now my question is, what is this doing exactly? What is this bill doing? And I'm reading that the change is everything is similar. I mean, you know, we use that instead of which, you know, and there's a few other, I would almost call technical changes, but the difference is these professionals, none of these professionals shall be before subject to a civil action for damages. And now we're changing it to shall be liable for damages. And I'm wondering, is that the gist of what this is about? Because otherwise, I mean, I would be happy for anyone on the committee to help me understand the you know, I'm fine with it. I think if they want it, I'm okay with it. I'm not trying to be adversarial about this bill, but I'm just trying to understand what is the difference here. Since my question yesterday, it seemed like it was the good faith piece. Thank you.
Representative Carmichael with an answer.
Okay, thank you.
First, this isn't my bill. Okay. I personally am not entirely sure it's necessary, but I think the reason we're going to arguably broader standard, civil versus liable, okay? And I don't actually have the bill in front of me, but I think the reason we're going to a broader standard is the particular district court case which brought rise to all of this concern is not the typical case where someone was injured because of the negligent driving error of another. Rather, it's all wrapped up in claims for what are described as cross claims by the Kansas Department of Revenue against the physician. And I presume that the Department of Revenue is alleging that in the issuance of a driver's license to a driver where there was questions about their vision, that they relied upon the report of the doctor. Now, I'm also told that in this particular case, the person got to go out and drive with the Highway Patrol as the representative of the Division of Motor Vehicles. But to the point of the matter is, I think they want protection, if you will, from the doctors want protection from a claim by the Department of Revenue that we relied on your report and now we got sued. And I think that's where it's going. Now, I see Representative Wheeler, who's also familiar with the facts, and he may help me out of this mess. But I think the case is in a procedural posture where my guess is if we came back a year from now, the court would have dismissed the claims that are of concern on a motion for summary judgment. But in the meantime, the practitioners need some reassurance that they have protection from these types of claims. We're going to put it in the register so it happens as soon as we can. And we're going to, quote, give them, unquote, the language that they feel like they really need.
Representative Ralph, and then Wheeler if necessary.
I don't know anything about the underlying case in Saline County, but just in looking at the language, what I thought was where they were headed was this changes the idea. First off, the subject to a civil action as opposed to liable for damages. I think that's just kind of how we make reference to those types of things now, as opposed to how we would have in the past. So some consistency in the language. And then what they're doing now is they're saying the doctor is doing something related to vision, and they struck out the language related to vision and not to safely operate a motor vehicle. So in the previous language, I'm assuming it could have been argued that the doctor was not only saying you've got good vision and you can safely operate a vehicle. We're striking out safely operate the vehicle. The doctor's just saying you've got good vision. I don't know whether you can drive or not. That's what I took from the strikes that was there.
Representative Wheeler.
If I may, in full disclosure, my oldest daughter is an optometrist and her husband is an optometrist as well. And to put this in full context, when we amended the law some years ago, where the person can go in, take that eye test, and if they don't meet the standard of whatever that is, I can't remember what it is, then you can go to your optometrist, and your optometrist is to examine your eyes and then send a report to DMV, their medical division. Well, that requires the doctor to give the exam and to report it. So here now they're required to give this, and yet they're being sued. And not only are they being sued because of some person's auto accident, they're being sued by the division themselves. And they're saying, and I can tell you, I can verify this, we're not doing those exams anymore. And there was an undertaking of saying, if this is the way this is going to work, we're not doing it. So that CDL driver who needs his license, this thing really needs immediate attention, and this cures it.
Any further discussion? That was a pretty good close, I think, even though it's not your motion. Representative Hoheisel, would you like to close?
Ditto everything Representative Wheeler said, and I close.
Heard the motion. All in favor say aye. All opposed say no. Motion carries. Yes votes. Hoheisel, Hobson, Carmichael, Heiberger. 419.
Mr. Chairman, Senate Bill 419 would allow certain employees from the Department of Corrections to attend the Kansas Law Enforcement Training Center. And it would also include special agents of the Department of Corrections and the definition of a law enforcement officer under the Kansas Law Enforcement Training Act.
Questions for Natalie? Are there any amendments? Seeing none, is there a motion? Representative Hoheisel.
Thank you, Mr. Chair. I move we pass out SB 419 favorably.
Is there a second? Representative Hobson. Discussion? Seeing none, may close.
Close.
All in favor say aye. All opposed say no. Motion carries. Yes votes Neely, Hoheisel, Hobson, Carmichael, Heiberger. Committee, is there any further business? Representative Hoheisel.
Thank you, Mr. Chair. I would like to make a motion to untable SB 395 and move it for action.
Is there a second? Representative Owens. No discussion. Except we did look at the minutes or the rules. We could have discussion if the chair determined we could have discussion, but we're not determining that. So all in favor of taking Senate Bill 390, untabling it. Yeah, taking 395 off the table. Say aye.
Aye.
Or say no. No. Ayes appear to have it. Division has been called. All in favor, raise your hand, please. Seven. Is that correct? I don't think she's not even online. All opposed? So it's 7-7. The chair votes aye. Would you like to remind us what 395 is about? What's that? Missing. So did everyone vote? It couldn't be 7-7. So hold on one second. Those in favor, raise your hand. Aye. 1, 2, 3, and number off. 1, 2, 3, 4, 5, 6, 7. So 7 in favor, right? Those opposed, raise your hand. 1, 2, 3, 8. Motion fails. So don't remind us what 395 was. Sorry for the miscounting. Okay, committee, any further business? Seeing none, this is likely our last meeting, but it never seems to be. It always seems like we'll be called back for some reason between now and the end of session. But appreciate everyone's work. We have an amazing staff that get us through this. We seem to generally operate fairly smoothly, and it's because of them. So working around the clock, literally, I send texts and get replies at all hours from all of everybody out here. So thank you all for that. Well, committee, again, this is it. I appreciate it. We will see you on the floor tomorrow. Have a good evening.